Hi, very good morning. This is again a very interesting case. Something which happens in a movie, similar to that. Supreme Court case. Citation is Om Sairam Steels and Alloys Private Limited versus Director of Mines and Geology. Facts of this case. Director of Mines is the OSS is the appellant. That is Om Sairam Steels is the appellant. Director of Mines is the first respondent. Then there are another two respondents are there. The facts are state of Odisha floated a tender for e-auction of mining lease of Vorahuri manganese iron and ore block. Online bids were invited. Sairam Steel, hereafter I will call it as OSS, submitted its bid along with others. A security deposit of rupees 9 crores approximately in the form of bank guarantee was also given. Floor price was fixed. Each bidder can propose their price over and above the floor price. The price has to be increased with a minimum of 0.05% within 8 minutes from the last highest bid. If not, the last highest bid would be declared as the winner. That is the tender condition. Bidding process started. It continued for 7 hours. There were 136 attempts under which the bid price was slowly increased by the bidders. The last bid was increased by 104.05%. This is very important. Please note. The last bid was increased by 104.05%. OSS, the appellant in this case, wanted to increase the bid by another 0.05%. That is, he wanted to quote 104.10%. Unfortunately, instead of typing 104.10, he typed 140.10%, an increase of 36% from the last bid price. Nobody countered it, so he was declared, OSS was declared as the highest bidder. OSS immediately realized the mistake. OSS made frantic calls to the concerned authorities, which went unanswered. The OSS immediately wrote an email and requested for rectification of bid. Sir, I have committed. Instead of saying 104, I typed 140. Please rectify this mistake. It was refused by way of a communication. They said nothing doing. Once you have submitted your bid, that is the end of the matter. They also said, please deposit the first installment within 15 days of your communication, this communication. If the first installment was not deposited, then we have no other option but to forfeit your security deposit of rupees 9 crores. Now he is caught because he has quoted 36% increase over the bid price. That is the highest. Nobody can venture into that project and expect to make some profit. Otherwise, his 9 crore security deposit will be forfeited. So, between the devil and the deep sea, OSS filed a writ petition before High Court on the ground of inadvertent human error. High Court rejected it. Sorry, you are the highest bidder, pay it. Then he went to Supreme Court. Supreme Court was shown step-by-step visual process of online bidding. Supreme Court in Patel engineering case held that negligent mistakes, that is another case, it held that negligent mistakes in bid documents could not be permitted to be corrected on the basis of equity. That is the judgment of Patel engineering. But Supreme Court noted certain special features in the present case. One, OSS made frantic calls on realizing the mistake which were unanswered. The respondent did not deny this. That is also very, very important. So when OSS said I made calls, respondent did not deny it. On the principle of doctrine of non-traverse, the averments made by OSS were deemed to be accepted by respondent. That is point number one. Point number two, email was written exactly 2 hours of submission of bid. Point number three, tender rules allowed only correction of clerical and arithmetical mistakes and not mistakes of this type. 4. There was no opportunity available on the platform to rectify the error. System was not permitting such a course. The bidder has only 2 options on realizing the mistake. That is, either forfeiture of security deposit on failure to deposit the first installment or quit the entire process. 5. From the overall circumstances, it was inferred that the mistake was only inadvertent. Supreme Court applied balancing test based on doctrine of proportionality. Balancing test permits scrutiny of excessive onerous penalties or infringement of rights or interests and a manifest imbalance of relevant consideration. Applying that test, Supreme Court held that it is as clear as daylight that forfeiture of entire 9 crores of security deposit is punitive in nature. The enforcement of an otherwise commercially unviable bid cannot be said to be in the interest of both the parties. That is what Supreme Court said. Supreme Court said that bidders being corporate entities are expected to have greater than ordinary degree of care, if not meticulous. Because you have got technical experts, you have got many experts. So you have to exercise greater care than the ordinary people. It directed OSS to pay rupees 3 crores since a new tender has to be floated. So that involves a lot of work and time. So it asked the OSS, you pay 3 crores. That is what Supreme Court ordered. The thing is, even inadvertent errors may cost a fortune for the company. Another point is, you can't treat all tenders as tender. Tender means, another meaning for tender is kind and loving. Sometimes they are very harsh. Thank you very much. Have a great day.